Hello NRIs, this is Sreejith Kuniyil. Today we are going to discuss a very interesting and important topic for NRIs. So recent times there are few videos spreading on the social media saying whenever NRI, especially from the Gulf NRIs, when they redeem mutual funds, the gain resulting from that redemption is not taxable in India. Few of my clients also asked me, Sreejith, is there any legal backup for this particular provision? Here, I would like to clarify and also would like to do a detailed content on this particular subject, whether gains arising from the redemption of the mutual funds are taxable in the hands of NRIs, especially from the GCC country. Let's get into the topic. Before discussing this particular topic, let's discuss how taxation works for NRIs. So, income tax in India governs under the Income Tax Act 1961. Every NRI is subject to tax in India under the Income Tax Act 1961, no doubt. Since you are a non-resident in India, you qualify to be a tax resident in your other country as well, right? Say for example, UAE tax resident or a Kuwait tax resident can claim a beneficial provisions under the double taxation avoidance agreement signed by the India. So almost 90 plus countries India has signed the tax treaties, including GCC country, except Bahrain. India has signed tax treaty with UAE, Kuwait, Oman and Saudi and Qatar, except Bahrain. So we don't know the reason why Bahrain has not signed a tax treaty with India. Now, so every NRI can compare the taxations under the Income Tax Act 1961 and also taxation under the double taxation avoidance agreement. Whichever is the more beneficial, he can take the treaty bill. The only condition, he should be qualified to be a tax resident in that particular country. Correct. Now comes to a point, units from a mutual fund. When you redeem, whatever the gain you are arising from that redemption is taxable or not in India. Without any doubt, under the Income Tax Act 1961, capital gain arising from the redemption of the mutual funds taxable in India. No doubt. Second question, is there any relief under the treaty? Relief under the treaty, just go through one particular treaty for an example. India UAE Tax Treaty, Article 13 has 5 clauses. For the benefit of the NRIs, let's read the Article 13. Article 13, as I mentioned, 5 clauses. We're not going to read the more full clauses, but let's read the clause 5 of Article 13. Gains from the alienation of any property other than that referred in paragraph 1, 2, 3 and 4 above shall be taxable only in the contracting state of which the alienator is a resident. Here, alienator is basically the transferor. For example, under this particular clause, if you earn any capital gain, that is taxable only in the country where the transferor is a resident. For example, if the transferor is from UAE, it is taxable only in the UAE, not in India. That is particularly this clause. Now the question is, how units of a mutual funds falls under this particular clause? Units of a mutual funds, certain people are interpreting units falls under this particular clause. The reason, there is another clause just above this 5, 4, clause 4, if you read, gains from the alienation of shares other than those mentioned in paragraph 3 in a company which is a resident of a contracting state may be taxed in that state. Here, you can just note this particular point, shares in a company. So the whole interpretation of units of a mutual fund is compared with this particular clause, they are saying units are not shares, mutual funds are not company. Okay, let's see, is there any legal backup in India? You come to couple of tribunal rulings. We've done a good amount of research on this particular subject and we found 2 tribunal rulings support this particular argument. Mumbai Tribunal in the case of Sri Satish Bahrilal Raheja in 2013 and later Cochin Tribunal in the case of K.E. Faisal in 2019 relied on the above tribunal ruling. Both the tribunals mentioned units of a mutual funds are not shares in a company. The whole concept they have taken, shares is not defined in the treaty. Since shares not defined in the treaty, they have taken the reference from the Companies Act 2013. Under the Companies Act 2013, shares as dividend rights, voting rights, it must be in a private limited company, in a public company, those types of things. So finally, because there is an Apollo ruling in the Supreme Court in the case of Apollo tires, it mentions units of UTAs are not shares in a company. So that's the whole base of this whole, both the tribunals. So finally, the argument is units of a mutual funds are not shares in a company. So since shares in a company not comes into the picture, they have taken the reference to this particular clause 5, which is a residual clause. Other than the for property, if any gain arising from this property is taxable only in the country where the transferor is a resident. Now the interesting part, nobody evaluated in detail what exactly the meaning for the shares in a company, scope of clause 4. Shares, here there is something missing. OECD, Organization of Economic Cooperation of Development, OECD governs the international taxations, economic policies of the countries. Under the OECD, shares has a wider meaning that includes fractional ownership, and also company is defined in the treaty. Company means any body corporate. Okay, so body corporate means any entity which is incorporated under any legislation in the country can be considered as a body corporate for the taxation purpose. That includes an LLP, trust. So any body corporate will falls under the ambit of company. So treaty, when it say company, doesn't mean it's a private limited company or a public company. So Article 13, this particular clause 4 has a very wider meaning. When I say shares, shares as a fractional ownership, company means any body corporate which is subject to tax in the country. So this is the biggest question mark. If the treaty is so clear, the exemption is so clear, why can't mutual funds entertain TRC and Form 10 from the NRIs to give the relief? That's not happening here right now. That's my concern. For example, if you see banks entertain TRC, I mean tax residency certificate and Form 10F, the TDS on the interest of 30% reduced to 10%. Dividend can also reduce from 20% to 10%. But such relief is we're not seeing in the mutual fund cases. They entertain TRC and Form 10F for giving this relief. Since if the treaty is so clear, the exemption is so clear, why can't the mutual fund entertain such exemptions? That's not happening. So one option is NRIs can approach income tax authority by filing a lower deduction certificate. Officers entertain such applications, giving such a relief. Or NRIs can approach income tax authority by filing an advance ruling. There is something called authority for advance ruling. That application also you can try. Third is any NRI association can approach income tax department directly to get a clarifications, internal circular or some clarification to the officers when we file such applications. If the treaty is so clear that units on mutual funds when you redeem, it is not taxable. So for taking this position, I never recommend an NRI to redeem your mutual funds when you return back to India. This is a concern most of the NRIs. They believe while you've been stayed so many years in the Gulf countries, when you return to India, you're planning to redeem these mutual funds. They are under impressions these are exempted in the country, since as long as you qualify to be a tax resident in that country. So my final conclusion is always do a cost benefit analysis. If your cost of effort, the cost of money involved to get a relief, better I think you don't need to approach. Otherwise tomorrow after 3-4 years down the line, this become a kind of a tax notice, or there is a possibility they may reopen the assessment. And if the money involved is huge, I always recommend you can approach income tax department by LDC route or a AR route. Still there is a relief available. You can, under the treaty, you can claim as an interpretation. As of now, other than those two tribunal rulings, not seeing much of the legal backup in India to support this tax position. So hope this video is useful for you. Please do share with your NRI circle, whoever is discussing the question on mutual funds are taxable or not in the hands of NRIs, especially for those NRIs from the Gulf regions. Thank you so much.